Learned additional public prosecutor was a bit lukewarm in submitting that some offence appears committed, but when the age of the victim was considered in the light of an unexplained delay of 19 days in lodging the report, the judgment and order of conviction and sentence appears not sustainable. Kidnapping or inducing any minor girl under the age of 18 years by any means whatsoever, so that she goes to any place or to do any act with intent as such that the girl is likely to be forced to illicit intercourse, are the ingredients which constitute offence under section 366A IPC. An offence under section 366 IPC contemplates kidnapping or abducting or inducing any woman with intent that she either may be compelled or is known likely to be compelled to marry any person against her will, or that she may be forced or seduced to illicit intercourse. Kidnapping is of two types. When it comes to kidnapping from lawful guardianship, then either the use of force or inducement is required to be the element of such acts, so as to taking the female under 18 years of age out of the keeping of her lawful guardianship. Taking away or inducing any minor are two terms which could be constituting the initial ingredients of section 366 IPC. Taking away necessarily envisages use of force, but when it comes to enticing away, then inducement doled out to a minor envisages some sort of cheating by misrepresentation of certain facts, which is the other aspect of kidnapping as regards enticing away a minor. Kidnapping by itself is an offence which could be sentenced under section 363 IPC. But abduction simpliciter is not an offence which could be punished. Abduction could be punished only when it is committed or done with certain intent or purpose, as could be gathered from different provisions like those contained in sections 364, 364A or 366 IPC. If the intent or purpose appears lacking, then the offences which could be punishable under section 366 IPC cannot be constituted likewise. If the elements of being enticed away or being taken away are also absent on account of lack of evidence, then also that offence could not be constituted, and no court could record any conviction against any person so as to inflicting any sentence upon him. Contention was seriously made on account of the acquittal of the appellant under section 366A IPC by Sri Pandey, that once a court was acquitting the appellant, it was held for all purposes that the lady was 18 years of age, and thus it was accepting the evidence of PW7, the doctor who had examined the victim and issued Exhibit 3. Thus the question which was to be decided by the court below, and which the court missed to decide, was as to whether the lady had been kidnapped, which necessarily envisages the use of force. It was contended that it is true that witnesses have stated that the victim was lifted on gunpoint, but her subsequent conduct, which was emerging from her own evidence, could be so glaring as not to lead any reasonable mind to a conclusion that she had indeed been abducted so as to be taken away to different places for the purpose which was alleged by her.